Bonjour, Monsieur le Président, honorable membre de la Cour. Donc, la Cour siège ce matin. Décision.
This morning to render 17 decisions and we proceeded here. We have 6 matters versus Tanzania, several versus Benin and other countries. We have 3 versus Mali, 2 Burkina Faso, 3 1 and we will have 1 versus Tunisia. May I pay your attention to the fact that the Tanzanian side is the state of Tanzania is represented here.
Je vous remercie.
We go to issue representing here as well.
Merci. Les membres du greffe, bonjour, honorable juge. Aujourd'hui,
I'd like to greet 2 honorable judges this morning. Which will be rendering in 17 matters. First, the United Republic of Tanzania. I would now like to request that the legal representatives
ici présents de se présenter.
who are here to introduce themselves.
Les affaires tanzaniennes.
Versus the United Republic of Tanzania.
Vice President of the Court, honorable judges, Deputy Registrar of the Court, if it may please you, my name is Nelson Sidney Ndeki from African Legal Attorneys and Consultant, and in this application, I'm representing the applicant. Much obliged.
Merci. Les avocats des requérants qui seraient présents.
Legal representatives who are present, kindly introduce yourself.
Justice of the Court, African Court. My name is Nkama Msade. We are ready to receive.
Merci. La Cour a pris acte de vos présentations.
On va commencer à entendre de la Cour en ce jour. Here, the decision that the court will now like to render the matter of Patrice Motiba. This decision will be presented by Honorable Judge Chizumila.
Thank you, Honorable President. This is the matter of Cleophas Maheri Motiba versus United Republic of Tanzania, application number 00055 of 2016, and it's a judgment. The court, composed of Blaise Chikaya, Vice President, Ben Kioko, Rafa Ben Ashur, Susan Menge, Tujilane Arachizumila, Chafika Ben Saula, Stella I Anukam, Dumisa Bin Sebeza, Modibo Sako, Dennis D. Ajay, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, and Rule 9.2 of the Rules of Court, Justice Imani D. Aboud, President of the Court and a national of Tanzania, did not hear the application. Facts of the matter. It emerges from the application that the applicant was employed as a civil servant on a permanent and pensionable basis by the respondent state's Ministry of Finance in one of the revenue departments as a finance manager officer. However, in 1995, the government of the respondent state converted its revenue departments to form an independent public corporate entity known as the Tanzania Revenue Authority. By virtue of the TRA Act number 11 of 1995, which came into force via the government notice number 419 of 1995. The applicant alleges that all employees, including him, who were part of the previous revenue departments, were assimilated into the TRA as its employees and not as civil servants. Subsequently, TRA undertook a screening of all its staff, as a result of which, on 14 April 1996, the Principal Secretary, Ministry of Finance, recommended the termination of 2 categories of staff in public interest. The 2 categories consisted of those who had a bad record in revenue collection and with doubtful integrity, and those whose performance was affected by advanced age, long sickness, and low education. The applicant avers that he was one of those who was unlawfully terminated by TRA, yet he did not fall into any of the 2 categories. He further avers that at the time of the retrenchment, he was barely 40 years old and was a graduate of the University of Dar es Salaam with a bachelor's degree in commerce and management. Furthermore, that no legal procedure was followed in terminating his employment. No reasons were given to support his termination, other than that the government had decided to reduce its workforce as a means of reducing its expenditure and increasing office productivity. The applicant states that after being served with the termination letter dated 25 June 1996, he wrote a letter of protest to the Permanent Secretary, Ministry of Finance, on 14 August 1997, to which the Permanent Secretary responded on 9 January 1999. Furthermore, that the Permanent Secretary had no power or authority to retrench him because he was no longer a civil servant, since his contract was transferred to TRA by virtue of the TRA Act, which came into existence on 7 August 1995. He also states that the respondent state paid him ex gratia, the terminology found in government retrenchment circular to civil servants. The applicant avers that being aggrieved with the reply to his letter of protest to the Permanent Secretary, Ministry of Finance on 1 October 1999, he and 6 other affected employees who are not before this court filed a case before the High Court at Dar es Salaam, civil suit case number 361 of 1999. the suit was filed against 3 entities, that is, the Principal Secretary, Ministry of Finance, the Attorney General, and TRA. Before the suit could be determined on the merits, the third respondent, that is TRA, raised 2 preliminary objections to the effect that the suit was bad in law for misjoinder of parties and revealed no cause of action against TRA. The High Court Judge, Bubeshi, rendered a ruling on 28 September 2001 upholding the preliminary objections and struck out TRA as a defendant. The applicant further avers that in considering the case, Judge Bubeshi also considered the question of whether it was TRA or the Ministry of Finance that was the applicant's employer. In so doing, the judge held that TRA had come into being on 1 July 1996. Therefore, the liabilities inherited did not extend to taking on former employees of the former revenue departments, since it had to engage its employees afresh. Aggrieved with the ruling of the High Court on the preliminary objections, the applicant appealed to the Court of Appeal in Civil Appeal number 17 of 2003 on 2 grounds. Firstly, that the trial judge was wrong to hold that the third respondent TRA came into being on 1 July 1996, and secondly, that the judge erred in holding that Section 28(2) of the TRA Act did not intend to include the former employees of the revenue departments. The applicant prayed the Court of Appeal to order TRA to be restored as a respondent in the suit. The applicant states that in a judgment dated 27 March 2006, Judge Mroso of the Court of Appeal observed, and I quote, that although the authority existed from 7 August 1995, it was an empty shell, a bus without a passenger, close quotes. He further observed that the process of operationalization commenced with the appointment of board members on 20 August 1995, and by 1 July 1996, the authority was ready to commence business as an authority. Judge Mroso also held that Judge Bubeshi erred in holding that TRA came into being on 1 July 1996. Rather, it came into being on 7 August 1995 as per Section 4 of the TRA Act, and that it was only the amendment of subsection 2 which came into operation on 1 July 1996. On the second ground of appeal, Judge Mroso held that this ground was misconceived, as nowhere in the ruling did Judge Bubeshi discuss Section 28(2) of the TRA Act, although she discussed Section 25(2) of the Act, which was premature. He also held that Judge Bubeshi should have confined herself to considering the 2 preliminary objections raised by the third respondent, TRA, rather than pronounce herself on the provisions of the TRA Act, which action would prejudice the trial of the case when it was considered on the merits. The Court of Appeal, therefore, allowed the appeal on the second ground and ordered that TRA be restored as a defendant in the suit because there was no doubt that the plaintiff disclosed a cause of action against the third respondent, TRA, and that it was rightly joined as a party in the suit. The Court of Appeal further observed that the grounds of appeal as presented by the appellants did not clearly capture the crux of the matter, which was striking out TRA as a respondent in the suit. It noted that the appellants could be forgiven for this, as the High Court judge had partially and prematurely strayed into the merits of the case. The Court of Appeal observed that it was nearly 8 years since the appellants had filed the suit, yet the case had not yet been considered on the merits. It therefore directed that the file be returned to the High Court for the resumption of proceedings by another judge. On 19 September 2006, the case was returned to the High Court and assigned to Judge Mihayo for resumption of trial in civil case number 361 of 1999. The court considered 4 issues, namely, first, whether TRA was in existence by 7 August 1995, and who was the plaintiff's employer. Second, who actually retired the plaintiffs and who had the authority to do so. Third, and 10, the applicant appealed against the decision of the High Court before the Court of Appeal sitting at Dar es Salaam in appeal number 27 of 2010. In its judgment, dated 15 December 2010, the Court of Appeal upheld the decision of the High Court. Dissatisfied with the decision of the Court of Appeal, in 2011, the applicant filed civil application number 13 of 2011, seeking a review of the judgment of the Court of Appeal. Excuse me. On 15 February 2013, the Court of Appeal dismissed the application for review for lack of merit. As a last resort, on 15 April 2015, the applicant filed a complaint with Commission for Human Rights and Good Governance. On 20 April 2015, the Commission informed the applicant that it had no jurisdiction to take up the matter as per section 130, subsection 5 of the Constitution of the respondent state. I now move to the prayers of the party. The applicant prays the court for the following measures and orders. A declaratory order that the decisions of the Principal Secretary Establishment, Bubeshi J. and Judge Mihayo, and the decision of the Court of Appeal of Tanzania, Civil Appeal number 27 of 2010 at Dar es Salaam, did not follow the law and did not consider my basic rights and the breach of the principle of natural justice, which I have suffered in the process of retrenchment, hence they are a nullity. Please note these are quotations of the applicant's prayers. The whole process of my retrenchment to be declared unfair, as it denied me to get employment elsewhere, hence the respondent should be ordered to pay me compensation equivalent to the amount of salaries and other employment I ought to get in the corporation as it was being reviewed time after time. C, I need legal aid because I have no money to employ an advocate. I have no job and my family is depending on me, so I need an advocate to represent me to the court. D, the courts to appoint experts who can assist the court in order to determine proper my application. The court to call witnesses who will be required by it and by the applicant. Any other enabling provisions of the law in the Constitution of the United Republic of Tanzania in Criminal Appeal number 60 of 2000. The applicant further prayed for reparations and for the court to grant the following reliefs. A, order the respondent state to pay the applicant a sum of Tanzanian shillings 500 million in US dollars, that's 200,000 US dollars, as general damages for violations of the Charter and Constitution, and as a result of the inconveniences and hardships suffered by the applicant following unlawful termination from employment and breach of employment contract. B, order the respondent state to pay the applicant a sum of Tanzania shillings 8,406,300 as a special damages for costs and expenses incurred and legal fees in respect of cases before the High Court, Court of Appeal of Tanzania, and in this court. C, order the respondent state to pay the applicant the pension on the total amount of salaries for the period of 20 years from 1996 to July 2016, when he would attain compulsory retirement age. D, order the respondent state to pay the applicant salaries for the period of 20 years from 1996 to July 2016. E, order the respondent state to pay the applicant gratuity based on the total income from employment for the period of 1996 to July 2016. F, any other reliefs the court deems just and equitable to grant in the circumstances in the application. In its response, the respondent state praised the court for the following orders with respect to the jurisdiction and admissibility of the application. A, that the Honorable Court on Human and People's Rights is not vested with jurisdiction to adjudicate the application. B, that the application has not met the admissibility requirements stipulated under Rule 4050 and 45 and 46 of the Rules of Court. That the application be declared inadmissible and duly dismissed. D, that the cost of the application be borne by the applicants. With regard to merits of the application, the respondent state praised the court to order the following. A, that the government of the United Republic of Tanzania did not violate the applicant's right to equality before the law and equal protection of the law provided under Articles 31, 2 and 2 of the African Charter on Human and People's Rights. B, that the government of the United Republic of Tanzania did not violate the applicant's right to have his cause heard as provided by Article 7.1 of the African Charter on Human and People's Rights. C, that the government of the United Republic of Tanzania did not violate the applicant's right to be tried within a reasonable time as provided by Article 7.1d of the African Charter on Human and People's Rights. D, that the matter has been concluded by the Court of Appeal of Tanzania E, that the application is totally void of merit. F, that the applicant's prayers be dismissed in their entirety. G, that the application be dismissed in totality for lack of merit. H, that the cost of the application be borne by the applicant. With regard to reparations, the respondent state prayed the court to dismiss the applicant's prayer in its entirety. I now come to the operative part. For the reasons given, the court unanimously on jurisdiction, 1, dismisses the objection to its jurisdiction. 2, declares that it has jurisdiction. On admissibility, dismisses the objections to the admissibility of the application. 2, declares the application admissible. On merits, finds that the respondent state has not violated the applicant's right to work, guaranteed under Article 15 of the Charter. 2, finds that the respondent state has not violated the applicant's right to fair trial, guaranteed under Article 7.1 and 7.1d of the Charter. 3, finds that the respondent state has not violated the applicant's right to equality before the law or to equal protection of the law, guaranteed under Article 3.1 and 2 of the Charter. Finally, finds that the respondent state has not violated the applicant's right to freedom from discrimination, guaranteed under Article 2 of the Charter. On reparations, dismisses the applicant's prayers for reparations. On costs, orders that each party shall bear its own costs. This judgment is signed by Blaise Chikaya, Vice President, Ben Kioko, Judge, Rafa Ben Ashur, Judge, Susan Menge, Judge, Tujilane Arachizumila, Judge, Chafika Ben Saula, Judge, Stella I Anukam, Judge, Dumisa Bin Sebeza, Judge, Modibo Sako, Judge, Dennis D. Ajay, Judge, and Robert Eno, Registrar. Done at Arusha, this 22nd day of September, in the year 2022, in English and French, the English text being authoritative.
Telle est la décision de la Cour. La suivante affaire est l'affaire Joseph contre la Tanzanie. The matter of Joseph John versus the United Republic of Tanzania, application number 005/2018, judgment on the 22nd September 2022. The court is composed of Blaise Chikaya, Vice President, Ben Kioko, Rafaj Ben Ashur, Susan Menge, Tujilane R. Chizumila, Shafika Ben Saula, Stella I. Anukam, Dumisa Bin Sebeza, Modibo Sako, Dennis D. Ajay, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, the Protocol, and Rule (2) of the Rules of Court (the rules). Justice Imani Diabode, President of the Court and the National of Tanzania, did not hear the application. Facts of the matter, and will read them as they are written, that the applicant humbly prays this honorable court
to restore justice where it was overlooked and quash both conviction and sentence meted out on me, which violated Section 2 of the Minimum Sentence Act number 1 of 1972, and order to my immediately release from the prison and just to grant in the circumstance of my complaints. In reply, the applicant further praised the court to find the application admissible, to find that it has jurisdiction to hear the application, 3, find that the respondent state violated Article 7, brackets 1, brackets B, brackets C, and D of the Charter. 4, make order to release the applicant from prison. 5, order the respondent to pay the applicant reparations. 6, issue any other order that the court may deem fit and just to grant. The respondent state praised the court to order A, that the African court is not vested with the jurisdiction to adjudicate the application. B, that the application has not met the admissibility requirements provided by Article 56, bracket 6 of the Charter, Article 6, brackets 2 of the Protocol, and Rule 40, bracket 6 of the rules. That the applicant be declared inadmissible, that the application be declared inadmissible, that the application be dismissed, that the respondent has not violated the applicant's rights under Article 7, brackets 1, brackets C, and Article 7, brackets 1, brackets D of the Charter, that the respondent has not violated any of the applicant's rights under the African Charter on Human and People's Rights. Now, the court went on to consider and reason on the following topics: jurisdiction, admissibility, merits, reparations, and costs. And thereafter, the court came to the operative part after having done all that exercise. And in the operative part, the court stated, for these reasons, the court unanimously on jurisdiction dismisses the objection to its jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objection to the admissibility of the application, declares that the application is admissible. On merits, finds that the respondent state has not violated the applicant's right to be tried within a reasonable time under Article 7, brackets 1, brackets D of the Charter. 6, dismisses the allegation that the applicant should have been tried before the juvenile court. 7, finds that the respondent has violated the applicant's right under Article 6 of the Charter by failing to inform him of his right to bail. 8, finds that the respondent state has violated the applicant's right to defense under Article 7, brackets 1, brackets C of the Charter, as read together with Article 14, brackets 3, brackets D of the International Covenant on Civil and Political Rights for failure to provide the applicant free legal assistance. On pecuniary reparations, the court dismisses the applicant's prayer for damages for material prejudice that he and the alleged indirect victims allegedly suffered. By a majority of 9, 4, and 1 against, Justice Shafika bin Saula dissenting, the court dismisses the applicant's prayer for damages for moral prejudice suffered by the alleged indirect victims. The court unanimously, 11, grants the applicant's prayer for reparations for the moral prejudice as a result of the violations found and awards him the sum of 600,000 Tanzanian shillings. 12, orders the respondent state to pay the amount set out under 11 above, tax-free, as fair compensation within 6 months from the date of the notification of judgment, failure of which it will be required to pay interest on arrears calculated on the basis of the applicable rate of the Bank of Tanzania throughout the period of delayed payment until the accrued amount is fully paid. On non-pecuniary reparations, the court dismisses the applicant's prayer for setting aside of his conviction and sentence and his release from prison. On implementation and reporting, the court orders the respondent state to submit to it within 6 months from the date of notification of this judgment a report on the status of implementation of the orders set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On course, dismisses the applicant's prayer for reimbursement of legal fees, costs, and other expenses incurred in the proceedings before this court. Orders that each party shall bear its own cost. This judgment is signed by Blaise Chikaya, the Vice President, Ben Kyoto Judge, Rafa Ben Ashur Judge, Susan Mengwe Judge, Tujilani Chismila Judge, Shafika Ben Saula Judge, Stella Anukam Judge, Tunisia B, Seveza Judge, Motiba Sako Judge, Dennis D. Adjei Judge, and Robert Ino, the Registrar. In accordance with the Article 28.7 of the Protocol and Rule 71 of the rules, the dissenting opinion of Justice Shafika bin Saula is appended to this judgment. Done at Arusha, this 22nd day of September in the year 2022 in English and French, the English text being authoritative. I hand down the judgment.
Merci, honorable juge. Quelle est la décision?
That is the decision of the court. The next matter
Ali
is the matter of Hussein Ali Fundumu versus United Republic of Tanzania, to be read by the Judge Dean
Ben Kyoko.
Judge Ben Kyoko. Judge, you have the floor.
Thank you, Honorable Vice President. This is the judgment of the court in the matter of Hussein Ali Fundumu versus United Republic of Tanzania, application number 016 of 2018, ruling. The court composed of Blaise Chikaya, Vice President, Ben Kioko, Rafa Benashu, Susan Menge, Tujilane Ara Chisumila, Shafika Ben Saula, Stella I Anukam, Dumisa B. Zebeza, Modibo Sako, Dennis D. Ajay, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights, on the establishment of an African Court on Human and People's Rights, and Rule 8.2 of the Rules of Court, Justice Imani D. Aboud, President of the Court and a national of Tanzania, did not hear the application. Facts of the matter. It emerges from the application that on 1 August 2004, in Misha village in the Tabora region, the applicant, together with two others not before the court, allegedly stole a mattress, a bicycle, a bag of clothing, and a machete belonging to Isa Kalfani and Aisha Said. In the course of the robbery, the applicant with his co-accused assaulted the victims with a machete, wounding them badly, and discharged a firearm as they fled the scene of the crime. The assailants were arrested and charged with armed robbery and tried at the District Court of Tabora on 26 May 2005. The applicant was sentenced to 30 years imprisonment, while the other two co-accused were acquitted. The applicant, being aggrieved by the decision of the District Court of Tabora, filed an appeal before the High Court of Tanzania at Tabora, which on 31 August 2007 dismissed the appeal for lack of merit and upheld the decision of the District Court on the ground that the applicant was clearly identified. The applicant, being also dissatisfied with the decision of the High Court of Tanzania sitting in Tabora, filed an appeal before the Court of Appeal of Tanzania at Tabora. On 18th June 2011, the Court of Appeal dismissed the appeal on the ground that the doctrine of recent possession was correctly applied, and the court therefore upheld the decision of the High Court of Tanzania. Prayers of the parties. The applicant prays the court to protect all rights violated by the respondent, declare the application admissible, order reparations for the violations of rights found, quash the sentence, and set him free. On his part, the respondent state prays for the following measures and orders in respect of the court's jurisdiction and admissibility of the application. This honorable court is not vested with jurisdiction to adjudicate over this application. B, the application has not met the admissibility requirements stipulated in Article 56(5) and 6 of the Charter and Article 6(2) of the Protocol and Rule 40, Sub-Rule 5 and 6 of the Rules of the Court. And C, the application be declared inadmissible. D, the application be dismissed in accordance with Rule 38 of the Rules of Court. And E, the cost of this application be borne by the applicant. In his response to the merits of the application, the respondent state prayed for the following measures and orders. A, the respondent state has not violated the rights of the applicant provided under Article 3.2 and 7.1c of the Charter. The application be dismissed for lack of merit. The applicant should not be granted reparations. The applicant should continue to serve his sentence in prison. The applicant's prayers be dismissed, and the cost of this application be borne by the applicant. I now go straight to the operative part of this judgment. Since we have 17 judgments to read, we cannot read everything. Operative part. For these reasons, the court unanimously on jurisdiction dismisses the objections to its jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objection based on non-exhaustion of local remedies, upholds the objection based on the failure to file the application within a reasonable time, declares the application inadmissible, and on cause, orders that each party shall bear its own costs. This ruling has been signed by all the judges whose names I read at the beginning, done at Arusha, this 22nd day of September in the year 2022, in English and French, the English text being authoritative. That's the judgment, the ruling of the court in this matter.
Quelle est la décision de la Cour?
The ruling of the court. The next matter is the matter of Abdallah Sospita Mabomba and others versus the United Republic of Tanzania. This ruling will be read by Justice Chizumila. You have the floor.
Thank you, Honorable President. The matter of Abdallah Sospita Mabomba and others versus United Republic of Tanzania, application number 017 of 2017. It is a ruling. The court, composed of Blaise Chikaya, Vice President, Ben Kioko, Rafa Ben Ashur, Susan Menge, Tujilane Ara Chizumila, Chafika Ben Saula, Stella I Anukam, Dumisa Bin Sebeza, Modi Bosako, Dennis D. Ajay, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, and Rule 9.2 of the Rules of Court, Justice Imani D. Aboud, President of the Court and the National of Tanzania, did not hear the application. Facts of the matter. It emerges from the record that on 27 December 1999, the applicants robbed a shop attendant at a gunpoint of Tanzania shillings 160,000 as he went to open the shop. In the course of the robbery, the applicants instructed the shop attendant to call out for the shop owner who lived adjacent to the shop, which he did. In response to the call, the shop owner and his wife opened the door to their house. At that point, the shop owner was assaulted with an iron bar, which led him to fall on the floor. As he lay on the floor, the applicants led his wife outside the house and gang raped her. On 16 February 2001, the applicants were jointly charged, together with others not before this court, with 2 offenses, namely armed robbery and gang rape at the District Court of Musoma. They were convicted of both offenses on 16 July 2002 and sentenced to 30 years imprisonment for the armed robbery as well as life imprisonment for the gang rape to be served concurrently. The applicants appealed the decision to the High Court of Tanzania, sitting at Mwanza, which on 2 July 2004 upheld the decision of the district court. They further appealed to the Court of Appeal, which dismissed their appeal in its entirety on 16 March 2007. I go to the prayers of the parties. The applicants pray the court to restore the justice where it was overlooked and quash both the conviction and sentence imposed on them and set them free, as well as grant them any other order it deems fit. With respect to jurisdiction and admissibility, the respondent state praised the court to find, 1, that the Honorable African Court on Human and People's Rights is not vested with jurisdiction to adjudicate over this application. 2, that the application has not met the admissibility requirements required under stipulated under Rule 45 of the Rules of Court or Article 56 and Article 6(2) of the protocol. 3, that the application has not met the admissibility requirements stipulated under Rule 46 of the rules and Article 6(2) of the protocol. 4, that the application be declared inadmissible. 5, that the application be dismissed in accordance to Rule 38 of the rules of the court. 6, that the cost of this application be borne by the applicants. With respect to the merits of the application, the respondent state praised the court to find, 1, that the government of the United Republic of Tanzania did not violate the rights of the applicants provided under Article 3(2) of the African Charter on Human and People's Rights. 2, that the government of the United Republic of Tanzania did not violate the rights of the applicants provided under Article 7(1)(c) of the African Charter on Human and People's Rights. 3, that the application be dismissed for lack of merit. 4, that the applicants not be granted reparations. 5, that the applicants continue to serve their sentence. 6, that the applicants' prayers be dismissed. 7, that the costs of the application be borne by the applicants. I now move to the operative part. For the reasons given in this ruling, the court unanimously on jurisdiction, 1, dismisses the objections to its jurisdiction. 2, declares that it has jurisdiction. On admissibility, 1, dismisses the objection based on non-exhaustion of local remedies. 2, upholds the objection that the application was not filed within a reasonable time. 3, declares that the application is inadmissible and dismisses it. On costs, orders each party to bear its own costs. This ruling has been signed by the judges I mentioned before, done at Arusha this 22nd day of September in the year 2022 in English and French, the English text being authoritative. This is the ruling in this matter.
Quelle est la décision de la Cour en l'affaire?
The ruling of the court in this matter. Next matter is that of John Martin Marwa versus the United Republic of Tanzania. This matter will be read by Justice Ajayi. Dear colleague, you have the floor, Honorable Justice Ajayi.
Thank you, Mr. Vice President. The matter of John Martimawa versus United Republic of Tanzania, application number 021/2017, ruling, 22nd September 2022. The court, composed of Brice Chikaya, Vice President, Ben Kioko, Rafa Benasho, Susan Menge, Chujilin R. Mila, Chafika Benzaula, Stella I. Anukam, Dumesa B. Insebiza, Modibo Sako, Dennis D. Ede, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol of the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9.2 of the Rules of Court, hereinafter referred to as the Rules, Justice Mani D. Abbott, President of the Court and the National of Tanzania, did not hear the application. Facts of the matter. It emerges from the record before the court that the applicant allegedly instructed a secondary school student to accompany him at night in going after a number of students who were outside the school compound. On their way back, the applicant allegedly attacked the student and started to rape her. The student eventually managed to escape and ran back to the school, after which she reported the incident to the police. The applicant was subsequently arrested and charged before the district court in Ziga in criminal case number 198/2005 with the offense of rape. He was convicted and sentenced to 30 years imprisonment on 13th April 2006. The applicant filed a criminal appeal number 56/2006, which was dismissed by the resident magistrate's court, extended jurisdiction sitting at Tabora on 14th December 2007. The applicant filed a further appeal to the Court of Appeal of Tanzania sitting at Tabora, being criminal appeal number 22/2008. In its judgment of 22nd June 2011, the Court of Appeal dismissed the appeal in its entirety, and the applicant was ordered to pay compensation to the victim amounting to 500,000 Tanzanian shillings. Prayer of the parties. The applicant prays that this court restores justice where it was overlooked, quashes both conviction and the sentence of 30 years imprisonment imposed on him, and order his release from prison. He further prays the court to grant any other orders that may be appropriate in the circumstances of his case. The respondent state did not make any prayers. The court discussed jurisdiction and admissibility, operative parts. For these reasons, the court on jurisdiction unanimously declares that it has jurisdiction. On admissibility, by a majority of 9 for 4 and 1 against, Justice Chafika Benzaula dissenting. 2, finds that the application was not filed within a reasonable time. 3, declares that the application is inadmissible. On costs, unanimously orders that each party shall bear its own costs. Signed by the judges whose names were mentioned earlier, together with the registrar. In accordance with Article 28(7) of the Protocol and Rule 71 of the Rules, the dissenting opinion of Justice Chafika Benzaula is appended to this ruling. Done at Arusha, this 22nd day of September in the year 2022 in English and French, the English text being authoritative.
Telle est la décision de la
This is the decision of the court. The next matter is that of Sijaona Shasha Mashera versus United Republic of Tanzania. This matter will be read by the Honorable Judge Anukam. Honorable Judge, the floor is yours.
C'est l'affaire Anoukam. No, they changed it.
No, they did not change.
Cher Ben Saoula, vous avez la parole.
Justice Ben Saoula, the floor is yours. Thank you, Mr. President. In the matter of Sijana Shasha Machera versus United Republic of Tanzania, application number 035-2017. The judgment is read today on the 22nd of September 2022. The court composed of Blaise Chikaya, Vice President, Ben Kiokora for Benashu, Susan Mengu, Tujidana R. Chizumina, Shafika Ben Saoula, Stella Ayanukam, Denisa Sebasa, Modibo Sako, and Denis Diajay, judges, and Robert Jenner, the registrar. In accordance with Article 22 of the Protocol of the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9.2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani Diabud, President of the Court and a national of Tanzania, did not hear the application. Subject of the application, facts of the matter, it emerges from the record that on the 8th of August 2007, the applicant allegedly asked one of his students, a boy aged 12 years, to his home. The applicant was supposedly going to inflict a punishment on the student by whipping him with a cane for getting a number of exercises wrong. However, the applicant then allegedly proceeded to undress himself and the student and had carnal knowledge of him against the order of nature. The applicant was charged on 13 August 2007 for having committed an offense against the order of nature contrary to Section 154A of the Respondent State's Penal Code. The applicant was arraigned before the District Court of Musoma
pénale 276-2007 et a été reconnu coupable puis condamné à 30 ans de réclusion le 21 mai 2008. Le 17 février 2009, le requérant a introduit un recours devant la Haute Cour siégeant à Mwanza dans l'appel en matière pénale numéro 31-2009 qui a été rejeté le 5 août 2011. Le requérant a ensuite formé un recours devant la Cour d'appel de Tanzanie siégeant à Mwanza dans l'appel en matière pénale numéro 223-2011, par son arrêt du 30 juillet 2013, ladite Cour a rejeté ce recours dans son intégralité. Le 23 septembre 2013, le requérant a déposé un recours en révision de l'arrêt de la Cour d'appel dans la requête en matière pénale numéro 17-2013, qui fut rejeté le 22 août 2017 au motif qu'il était dénué de tout fondement. Pour les demandes de parties, donc dans sa requête, il est demandé ce qui suit à la Cour. Rétablir la justice là où elle a été bafouée en annulant la déclaration de culpabilité ainsi que de la peine prononcée à l'encontre du requérant et ordonner sa remise en liberté, accorder toute autre réparation et mesure qu'elle estime appropriée compte tenu de la situation du requérant. Dans ses observations sur les réparations, le requérant demande à la Cour d'ordonner ce qui suit à l'État défendeur. Verser au requérant son salaire, majorer des augmentations annuelles pour la période comprise entre le 24 mai 2008 et la date de la fin de son contrat, verser au requérant les salaires de base non payés, majorés d'intérêt au taux de 25%, verser au requérant une compensation d'un montant total de 900 000 shillings tanzaniens à titre de réparation pour la souffrance physique et le traumatisme psychologique qu'il a subi et pour la perte de revenus ainsi que les souffrances endurées par
hardship for his loss of income. The applicant further praised the court to order the respondent state to supply him with his employment documents, including his contract of service, the letter terminating his employment, minutes of the meeting in which the decision to terminate his employment was made, his payslip, and any other document relating to his employment. Response. With regard to jurisdiction admissibility of the application, the respondent state praised the court to order the following measures. that the Honorable African Court on Human and People's Rights is not vested with jurisdiction to adjudicate this application, that the application be declared inadmissible, that the application be dismissed. With regard to the merits of the application, the respondent state prays the court to order the following measures: that the respondent state has not violated what the applicant was lawful and in accordance with the national laws, the charter, and international instruments. A declaration that the applicant's application for reparation is unfounded and devoid of merit for failing to meet the tests enshrined in the principles and prerequisites of reparations, an order for dismissal of the application for reparations with costs, any other order or relief that the court deems fit and does to grant. Following deliberations, the court declares and concludes that it does have jurisdiction
et sa compétence territoriale. Sur la recevabilité et
members of the court, as mentioned above, and the registrar, down at Arusha, this 22nd day of September in the year 2020, English and French, the English text being authoritative.
De la Cour.
This is the decision of the court.
La Cour va se retirer pour...
The court will rise for reconstitution of the bench.
5 minutes. Merci.
Hello. Hello. Sawa. Hamna kelele. Iko sawa. Sasa labda sikia anatumia ngoja nimuunganishie alafu atajaribu kuongea tena, sawa? Sawa.
La suivante affaire à prononcer.
Next matter. The matter of Bernard Abdallah Mona. The bench is composed of 7 judges, and one of the judges is not present. So the matter,
La juge Anoukam.
the judgment will be read by Justice Anoukam. Justice Anoukam, you have the floor.
Merci, Mr. President. The matter of Bernard Abdallah Mona, applicant, versus the Republic of Benin, Burkina Faso, Republic of Cote d'Ivoire, Republic of Ghana, Republic of Mali, Republic of Malawi, United Republic of Tanzania, the Republic of Tunisia as respondent states, and Sahrawi Arab Democratic Republic and the Republic of Mauritius as interveners. And the application is number 028/2018. It is a judgment. The court composed of Blaise Shikaya, Vice President, Ben Kyoko, Susan Menge, M. Teresa Mukamolisa, Shafika Bensaula, Stella I. Anoukam, Domisa B. Nsabeza, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9.2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani Diabud, Justice Rafa Benashu, Justice Tujalen R. Shizomila, and Modibo Sako, nationals of Tanzania, Tunisia, Malawi, and Mali, respectively, did not hear the application. The party is where it's represented, and all the respondent states are equally, the applicant is represented, and all the respondent states are equally represented in this matter. The interveners also have their representation. After deliberation, the court renders the following judgment. The parties, we have as party Bernard Mona, hereinafter referred to as the applicant, who is a Ghanaian national, and the national chairman of the Convention People's Party, a political party registered in Ghana. The applicant alleges violations of human rights of the Sahrawi people as a result of the failure of the respondent states to safeguard the territorial integrity and independence of the Sahrawi Arab Democratic Republic. The application is filed against the Republic of Benin, Burkina Faso, the Republic of Cote d'Ivoire, the Republic of Ghana, the Republic of Mali, the Republic of Malawi, and the United Republic of Tanzania and the Republic of Tunisia, hereinafter referred to as the respondent states. The subject of the application, the facts of the matter. The applicant alleges that the subject of his application relates to violations of the human rights of the Sahrawi people as a result of the erosion of their sovereignty, territorial integrity, and independence of Western Sahara due to the continued occupation of its territory by the Kingdom of Morocco. The applicant states that the territory known as Western Sahara was colonized by Spain until 1976. After Spain's departure in February 1976, according to the applicant, Morocco and Mauritania occupied Western Sahara, but were met with resistance from the Sahrawi people. As a result, Mauritania relinquished its claim to any part of Western Sahara. The applicant argues that Morocco still remains in occupation of the territory of the SADR. The applicant elaborates that in 1984, the SADR was admitted as a member of the Organization of African Unity, hereinafter referred to as the OAU, and subsequently became a founding member of the African Union, hereinafter referred to as the AU. In protest against the SADR's admission as a member of the OAU, Morocco left the organization in the same year. The applicant further states that in 1992, a UN-supervised referendum on independence of the SADR was promised, but it was aborted when Morocco objected to the proposed electoral register, when it alleged bias in favor of the secession. The applicant alleges that Morocco occupies the part of Western Sahara that harbors one of the world's richest fishery stock, abundant phosphate rock mines, and oil reserves, which it has been exploiting to the detriment of the Sahrawi people. The applicant also alleges that in 2017, Morocco applied for membership to join the AU and was admitted. The applicant advised that Morocco's admission to the AU was not based on a unanimous decision. According to the applicant, notwithstanding its admission to the AU, Morocco has not shown any intention of giving up its occupation of the Western Sahara. Furthermore, although the SADR had been recognized by the AU as a legitimate government in exile, and no less than 84 countries have accorded it diplomatic recognition, parts of Western Sahara remain occupied by Morocco. The applicant contends that the unconditional admission of Morocco to the AU also contradicts the established practice with regard to admission of members to the AU and its predecessor, the OAU. He recalls that apart from condemning illegal and unconstitutional change of government, the OAU and the AU have in the past refused to admit colonial powers as members. In this regard, the applicant refers as examples the OAU's refusal to admit South Africa during the apartheid regime, and more recently, OAU suspension from its membership of Cote d'Ivoire, Niger, Burkina Faso, and Egypt based on the unconstitutional removal of regimes by coup leaders. Alleged violation. According to the applicant, the admission of Morocco to the AU is inconsistent with the objectives and principles of the Union entrenched in Articles 3, 4, and 23 of the Constitutive Act, Articles 1 and 2 of the African Charter on Democracy, Elections and Governance, hereinafter referred to as ACDEG, and Articles 1, 2, 7, 13, 14, 20, 21, 22, 23, and 24 of the Charter. Finally, the applicant alleges further that even if the respondent state did not protest the admission of Morocco to the AU at the time the Assembly made the admission decision, the court should still hold them responsible for their failure, individually and or collectively, to defend the sovereignty, territorial integrity, and independence of the SADR and the right of its people to dispose of their wealth and natural resources. The prayers of the party. The applicant prays the court to issue, 1, a declaration that the failure of the defendants individually and or collectively to defend the sovereignty, territorial integrity, and independence of Western Sahara is illegal, as it directly violates Articles 3 and 4 of the Constitutive Act of the African Union, Articles 1, 13, and 20 of the African Charter on Human and People's Rights, Articles 1 and 2 of the International Covenant on Civil and Political Rights, and Articles 1 and 2 of the International Covenant on Economic, Social, and Cultural Rights. Secondly, a declaration that the failure of the defendants individually and or collectively to prevent Morocco from violating the human rights of the people of Western Sahara to dispose of their wealth and natural resources to their economic, social, and cultural development and peace guaranteed by Articles 19, 22, 23, and 24 of the African Charter, and similar provisions in common in Article 1 of both the International Covenant on Civil and Political Rights and of the International Covenant on Economic, Social, and Cultural Rights, in itself violates these rights. Thirdly, an order compelling and mandating the defendants individually and or collectively to call an emergency session of the Assembly of the African Union and to sponsor a resolution for the adoption of legal, political, and other measures by the African Union to restrain Morocco from further occupying parts of the territory of Western Sahara in any manner whatsoever and howsoever, as well as sponsor a motion for the immediate expulsion of Morocco from the African Union until it is prepared and ready to recognize the right of the Sahrawi people to self-determination. Mali, Burkina Faso, Tunisia, Cote d'Ivoire, and Ghana pray the court as follows. 1, to declare that it lacks jurisdiction, declare that the application is inadmissible, for the applicant has not demonstrated that he has a local standard and for failing to meet admissibility conditions specified under Article 56 of the Charter. Thirdly, dismiss the application as baseless, and fourthly, order the applicant to bear the entire cost. The countries of Tanzania, Malawi pray the court to dismiss the application for lack of jurisdiction. Tanzania also prays that the court should declare that the application is inadmissible for failing to meet the admissibility conditions specified in the Charter. It further prays the court to order that it is not in violation of Articles 3 and 4 of the Constitutive Act. It is also not in violation of Articles 1, 2, 7, 13, 19, 20, 21, 22, and 23 of the Charter, as well as Articles 1 and 2 of the ICCPR, as well as Articles 1 and 2 of the ICESCR. Thirdly, a declaration that the admission of Morocco to the AU was in accordance with the Constitutive Act of the AU and thus lawful. Lastly, dismiss the application with cost. The SADR as intervener prays the court to declare that it has jurisdiction, declare the application admissible, rule that the application is well-founded and justified. Benin did not make any submission or prayers. On jurisdiction, The respondent states raised objections to the material, personal, territorial, and temporal jurisdiction of the court. After an elaborate deliberation and consideration of all the objections to its jurisdiction, as well as the submissions by the applicant and the amicus curiae, the court concludes that it has material, personal, temporal, and territorial jurisdiction, and thus is competent to determine the application. On admissibility, the respondent states equally raised objections to the admissibility of the application based on Rule 50 sub 2A to B and D up to G of the rules. After an elaborate deliberation and consideration of all the objections raised by the respondent states and the submissions by the applicant as well as the amicus curiae, the court finds that the application meets all the admissibility conditions specified under Rule 50 sub 2 of the rules. The court therefore declares that the application is admissible. We now go to the merits of the case. The court will now decide on the merits of the case after first setting out the various submissions and observations of the parties. The applicant's submission. The applicant asserts that when Morocco applied for admission to the AU, it was not required to end its colonization and occupation of Western Sahara. According to the applicant, this is despite the respondent state's individual and collective obligation to defend the sovereignty, territorial integrity, and independence of Western Sahara under Articles 3 and 4 of the Constitutive Act. The applicant alleges that the respondent state's failure to discharge their obligation and prevent Morocco from continuing to occupy the territory of the SADR has resulted in the violation of the right to self-determination, the right to freedom from discrimination, the right to a fair trial, the right to participation in political activities, the right to equality of all peoples, the right to peace, the right to satisfactory environment, and the right to dispose of wealth and natural resources, and the right to economic, social, and cultural development of the people of Western Sahara, contrary to Articles 1, 2, 7, 13, 19, 20, 21, 22, 23, and 24 of the Charter, and the common Article 1 of both the ICCPRO and ICESCRO. The applicant further alleges that the respondent states have also violated Articles 1 and 2 of the African Charter on democracy, elections, and good governance of the African Union. The respondent states submission. Burkina Faso, Mali, Tunisia, Tanzania, and Cote d'Ivoire argue that they do not have responsibility for a decision made by the AU or have powers to interfere in matters between sovereign states, and that the violations that were alleged to have occurred are outside their own jurisdiction. In this regard, Burkina Faso and the Republic of Mali specifically assert that pursuant to Articles 3 and 4 of the Constitutive Act, they have the duty to respect the sovereignty of other member states and to refrain from intervening in their internal affairs. Regarding the decision of the AU Assembly to admit Morocco to the AU, Burkina Faso, also joined by Mali, recalls that the African Union never excluded Morocco, in which case its return would have been subject to a prior meeting to discuss the conditions that led to the exclusion. It advised that Morocco voluntarily withdrew from the institution in 1984, but in 2016 made known its intention to return, and its admission was accepted by an overwhelming majority. On its part, Tanzania reiterates its position that the readmission of Morocco back to the AU was not done by the respondent state, rather by the AU Assembly. Cote d'Ivoire submits that it has no obligation towards the SADRO, and the applicant's complaints reveal no concrete facts constituting the breach of any obligation incumbent upon the state of Cote d'Ivoire. In addition, Cote d'Ivoire questions how the mere fact of Morocco's admission to the AU violates the rights of the Sahrawi people. The Republic of Ghana avers that the issue of self-determination is a political question and should be resolved politically. Furthermore, it is the view of Ghana that the admission of Morocco to the AU was done with a view to achieving greater unity and solidarity between African countries and the people of Africa in accordance with the Constitutive Act. The intervenant's submission. This is, I'll read the submission by the Sahrawi Arab Democratic Republic, which is abbreviated as SADRO. The SADRO asserts that the respondent states have failed in their obligations towards the Sahrawi people at the time of admission of Morocco into the AU. It submits that the right to self-determination is a fundamental human right and a preparatory norm of international law, which imposes an obligation orga omnes on all states to ensure its respect. Submission by the second intervener, Mauritius. On its part, the Republic of Mauritius, citing the ICJ's advisory opinion on the legal consequences of the separation of the Chagos archipelago from Mauritius, underscores that the respect for the right to self-determination is an obligation orga omnes, which all states have legal interest in protecting it. Mauritius further contends that the complete decolonization of the African continent cannot be achieved without the elimination of the remnants of colonialism still existing in a few territories on the continent. In this regard, it submits that Mauritius supports the right of the Sahrawi people to self-determination, including their right to dispose of their natural resources, It recognizes SADRO as a sovereign and independent state, pledges its continued solidarity with the Sahrawi people in their struggle for self-determination, and backs the implementation of all UN resolutions and the AU decision pertaining to SADRO. The submission for the amicus curiae. Palu avers that the right to self-determination imposes an obligation orga omnes on the respondent states, and in determining the scope of such obligation, the court should look at the various resolutions of the AU and its predecessor, the OAU. The position of the court. The court notes that at the core of the instant application lies the applicant's allegation that the admission of Morocco to the AU was not opposed by respondent states in spite of their individual and collective obligation to defend the sovereignty of Western Sahara. The court further notes that the applicants alleges violation of several rights of the Sahrawi people, including the right to non-discrimination, the right to a fair trial, and the right to participation in political activities of one's own country, the right to equality of all peoples, the right to self-determination, the right to dispose of natural resources, the right to development, the right to peace, and the right to satisfactory environment. Considering the facts of the case and the submission of the parties, the court is of the view that the present application is essentially and firmly linked to the right to self-determination, particularly the right of the Sahrawi people to obtain assistance in their struggle for freedom from foreign occupation. Although the other rights are autonomous by nature, their violation in the instant case basically flows from the alleged denial of the right to self-determination of the people of Western Sahara. It is the occupation of the SADRO and the deprivation of its people of their right to self-determination that have occasioned and facilitated the alleged violations of their other rights, including their right to development, right to disposal of their natural resources, their right to peace, and to non-discrimination. In these particular circumstances, The court therefore deems it unnecessary to deal with them and thus limits its determination to the alleged violation of the right to self-determination of the people of the SADR and putative responsibility of the respondent state with regard to such violation. The court observes that the 8 respondent states are in no way alleged to have collectively or individually engaged in undertakings to conquer or to annex the territory of the SADR. However, the applicant asserts that in conducting their international affairs, particularly while voting to admit Morocco to the AU, the respondent states did not take into account their obligation to support and protect the Sahrawi people against violations resulting from Morocco's occupation. Accordingly, in the application of Article 20 of the Charter, which relates to the right to self-determination, the conduct of these 8 states with regard to the SADR should be distinguished from that of Morocco, which is alleged to have directly violated the rights of the Sahrawi people through occupation. However, the alleged Morocco's conduct is not the subject for the court determination, as Morocco is not a party in this case. It is therefore the view of this court that the conduct of the respondent state should be determined in the light of their obligation arising from Article 20, sub 3 of the Charter, which declares as follows: all people shall have right to the assistance of the states parties to the present Charter in their liberation struggle against foreign domination, be it political, economic, or cultural. The court also finds it pertinent that such determination of the respondent state's responsibility under the above provision should consider the nature of the right of self-determination in general and its unique place and relevance in the African continent and to the African society in particular. In this regard, the court observes that the notion of self-determination has strong resonance with Africa and carries a special and deep meaning to his people. It is for this reason that when the OAU was established in 1963, the Assembly, having been convinced that it is the inalienable right of all people to control their own destiny, expressed their determination to safeguard and consolidate the hard-won independence, as well as the sovereignty and territorial integrity of our states, and to fight against neo-colonialism in all its forms. The charter establishing the OAU has also stipulated that the eradication of all forms of colonialism from Africa was one of the principal purposes of the organization. The charter guarantees the right to self-determination under its Article 20 as follows: all people shall have the right to existence. They shall have the unquestionable and inalienable right to self-determination. They shall freely determine their political status and shall pursue their economic and social development according to the policy they have freely chosen. In comparison with the corresponding provisions of the ICCPR and ICESCR, and Article 20 of the Charter further offers broader and stronger protection to the right to self-determination, again reflecting the importance African states attach to self-determination. The court knows that the right to self-determination imposes both positive and negative obligations on state parties. The court also observes that in international law, the right to self-determination has achieved the status of jus conjuris or a preparatory norm, thereby generating the corollary obligation unga omnes on all states. As such, no derogation is permitted from the right, and all states have a legal interest in protecting that right. Where a presumptory norm is breached, states are also under an obligation not to recognize the illegal situation resulting from such breach and not to render aid or assistance in maintaining the situation. The court further observes that the right to self-determination is essentially related to people's right to ownership over a particular territory and their political status over the territory. It is inconceivable to materialize the free enjoyment of the right to self-determination in the absence of any territory that peoples could call their homeland. In this regard, the court notes that both the UN and the AU recognize the situation of the SADRO as one of occupation and considers its territory as one of those territories whose decolonization process is not yet fully complete. As a result, both organizations have consistently called for Morocco and SADRO to engage in direct negotiations in good faith with a view to conducting a referendum to ensure the right to self-determination of the people of Western Sahrawi. The court calls that although Morocco has always laid claim on the territory it occupies, its assertion has never been accepted by the international community. In fact, in 1975 advisory opinion, the ICJ found no evidence to establish any historical tie of territorial sovereignty between the territory of Western Sahara and Morocco, and concluded that Morocco had no legal ties of such a nature with Western Sahara to affect the application of the UN General Assembly Resolution of 1514-1960 in the decolonization of Western Sahara, and in particular, the respect for the principle of self-determination through the free and genuine expression of the will of the people of the territory. Accordingly, as far as the issue of ownership of the territory of Western Sahara is concerned, it is a settled fact that the court should take judicial notice of in its assessment of the instant application. The court stresses that the continued occupation of the SADRO by Morocco is incompatible with the right to self-determination of the people of the SADRO as enshrined in Article 20 of the Charter. The question here is whether the respondent states should be held responsible for such violation. The parties disagree on this point. Now we'll look at, I'll read our judgment on the determination of the responsibility of the respondent state. The court recalls that in international law, a state incurs international responsibility where three cumulative conditions are proven to have existed: an act or omission violating international law. That is, an internationally wrongful act. The act must be attributed to a state, and the act must cause a damage or loss. In addition, there should not be circumstances precluding responsibility. The court will now consider whether the respondent states in the instant case should be held responsible for failing to end the occupation of Western Sahara, or to make the admission of Morocco to the AU conditional in respect for territorial integrity, independence, and sovereignty of the SADRO, as well as the right to self-determination of the Sahrawi people. The court notes that in view of the fact that part of this SADRO's territory is still under occupation by Morocco, there is no question that state parties to the Charter have an obligation, individually and collectively, towards the people of SADRO to protect their right to self-determination, particularly by providing assistance in their struggle for freedom, and by not recognizing Morocco's occupation and any human rights violation that might have resulted from such occupation. The issue for determination is whether the respondent states, contrary to the said obligation, have shrinked their responsibility in the Charter by either failing to give assistance to the people of SADRO or by recognizing the illegal occupation by Morocco of the SADRO's territory, contrary to the people's right to self-determination. That is, whether they are engaged in conduct that would amount as internationally wrongful acts. The court observes that although both the applicant and the SADRO assert that the fact of admission in and of itself is not the basis of their application, the conduct of the respondent states that they are complaining about is basically related to the said admission. The court accordingly notes that in order to establish the internationally wrongful act of the respondent state, it is imperative to examine the overall context of the decision of Morocco's admission as a member to the AU and the role of the respondent states in the process. The court shall particularly ascertain whether the respondent states have complied with their obligation under the Charter. Furthermore, the court should establish whether there is any wrongful act that could be impugned to the respondent states and whether there is a causal link between such wrongful acts and the violation of the right to self-determination of the people of the SADRO. The court recollects that Morocco withdrew from the OAU in 1984, protesting the sitting of a delegation of the Polisario Front representing the SADRO, an independent state, which was admitted into the organization in 1982. It is to be noted that Morocco's departure was not its own decision, and not as a result of the decision of the organization. For instance, in the form of sanction for violating the territorial integrity of the SADRO or the right to self-determination of the peoples of the Western Sahara. 32 years later, on 22nd of September 2016, Morocco officially made its request to join the African Union, the successor to the OAU. And on 31st January 2017, the AU Assembly admitted Morocco as member to the AU. None of the respondent states disputed that they voted in favor of the admission. It is evident from the proceeding that the respondent states were aware of Morocco's request to join the AU as early as September 2016. It is also true that from that moment on, the respondent states in their individual capacity could have taken certain steps, such as attempt to galvanize support from other state parties to the Charter, to object to Morocco's admission, or make its admission conditional on its respect for the right to self-determination of the people of Western Sahara. However, it is the considered view of the court that there is no evidence before it showing whether the respondent state did or failed to do so. In any event, even if evidence existed that the respondent state failed to do so, this would not in itself amount to a violation of their international obligation arising from the Charter. Firstly, Article 20 of the Charter imposes on the respondent states the duty to assist the people of SADRO in their struggle to realize the full enjoyment of their right to self-determination. But it does not require states to take a list of specific actions or measures of a particular nature. Therefore, it is up to the respondent states to choose the kind of positive measures that they consider appropriate for the realization of the right for the said people. In this vein, the court takes note of the respondent state submissions that they are supporting diplomatic efforts under the aegis of the AU and the UN to find political solutions. Although one may still question the adequacy of their measures, the respondent state cannot therefore be considered to have failed to discharge their obligation to assist the people of the SADRO or take positive steps required in the Charter to ensure the full realization of the right to self-determination of the Sahrawi people. Secondly, as some of the respondent states have rightly pointed out, the process of admission of a state to the AU is not the exclusive role of one or more of the respondent states. Certainly, individual member states of the AU can, in the exercise of their rights of membership, vote in favor or against the admission. However, such act of voting by a member state cannot in itself a priori constitute a breach of its international obligation, or in the instant application, a violation of the right to self-determination of Sahrawi people. Furthermore, in the present case, the court has no cogent evidence on record showing how the respondent states voted. Thirdly, the decision to admit a state as a member of the AU, including the inspection of whether the candidate state complies with the objectives and the principles of the Constitutive Act, which includes the protection and promotion of human rights in accordance with the Charter, or whether its admission should be attached to certain conditions, is the decision of the Assembly, not the individual member states. Accordingly, the respondent states Accordingly, the respondent state's individual decision to support or oppose the admission of Morocco does not alone necessarily determine the final outcome, nor could the respondent states individually or collectively determine the admission of a candidate state or subject it to conditions requiring it to respect the right to self-determination of the people of the SADRO. The court stresses that their inability to do so cannot constitute a breach of their international obligation in the Charter or violation of the right to self-determination of the people of the SADRO. The court wishes to point out that the admission of Morocco might be challenged as incompatible with the Constitutive Act, the determination of which is outside the competence of this court. However, the respondent state's individual decision to vote in favor of Morocco's admission to the Union per se cannot be taken as a recognition of Morocco's occupation of the territory of the SADRO or giving legitimacy to the resulting violations of the right to self-determination of the people thereof. With regard to the alleged human rights violation directly ensuing from Morocco's occupation of Western Sahara, the court finds it unnecessary to examine or pronounce itself on them, as Morocco is not a party to this case. As far as the responsibility of the respondent states are concerned, there is no evidence available before the court to attribute these violations to them. There is also no demonstrated causal link between the complaint conduct of the respondent states and such violations. In view of the foregoing, the court holds that the respondent states have not individually or collectively violated the right to self-determination of the people of the SADRO guaranteed under Article 20 of the Charter and Article 1 common to ICCPRO and ICECRO. Having heard that the respondent states have not violated the rights of the Sahrawi people, the court nevertheless reiterates that the respondent states, and indeed all state parties to the Charter and the Protocol, as well as all member states of the AU, have the responsibility under international law to find a permanent solution to the occupation and to ensure the enjoyment of the right to self-determination of the Sahrawi people, and not to do anything that will give recognition to such occupation as lawful or impede their enjoyment of these rights. We now go to read the aspect on reparation. The applicant prays the court to issue an order compelling the respondent state to individually and or collectively call an emergency session of the Assembly of the AU and to sponsor a resolution for the adoption of legal, political, and other measures by the AU to restrain Morocco from further occupying parts of the territory of the Western Sahara in any manner whatsoever and howsoever. The applicant also requests that such resolution should place Morocco on probation until it respects the rights of the Sahrawi people or be expelled from the Union. The court has consistently held that reparations are only awarded when the responsibility of the respondent state for an internationally wrongful act is determined and a causal link is established between the wrongful act and the alleged harm. The court has also adopted the position that it cannot order reparation measures based on allegations for which no human rights violation have been found. In the instant application, the court has not found any violations of human rights of the people of this SADRO by the respondent states, and thus the issue of reparation does not arise. Accordingly, the court dismisses the applicant's prayers for reparation. On cost, the applicant has not made submissions on cost. Tanzania argues that the application is frivolous and vexatious and prays the court to dismiss the application with cost. Mali, Burkina Faso, Tunisia, Cote d'Ivoire, and Ghana also similarly pray that the court should order the applicant to bear the cost. The other respondent states did not make submissions on cost. The court notes under Rule 32(2), on which states, unless otherwise decided by the court, each party shall bear its own cost, if any. In the instant case, the court sees no reason to depart from the above general principle, and accordingly, it decides that each party shall bear its own cost. The operative part of this judgment. For these reasons, the court unanimously on jurisdiction dismisses the objection to his jurisdiction, declares that it has jurisdiction. On admissibility, the court dismisses the objections to the admissibility of the application, declares that the application is admissible. On merits, finds that the respondent states have not violated the right to self-determination guaranteed under Article 20 of the Charter and other related rights alleged to have been violated by the applicant. On reparation, dismisses the applicant's request for reparation. On cost, orders each party shall bear its own costs. This judgment is signed by Blaise Shikaya, the Vice President, Ben Kyoko, the Judge, Suzanne Menge, Judge, M. Teresa Mukamulisa, Judge, Shafika Bensawla, Judge, Stella I. Anukam, Judge, Domisa B. Nsabesa, Judge, and Robert Eno, Registrar. In accordance with Article 28, Sub 7 of the Protocol and Rule 71, Sub 1 of the Rules, the separate opinion of Judge Blaise Shikaya is appended to this judgment. And this judgment is done at Arusha on this 22nd day of September in the year 2022 in Arabic, in French, in English and French, and the English text being authoritative.
Merci, honorable juge. Telle est la décision de la Cour.
Honorable Judge, such is the judgment of the court. The court will rise for reconstitution. Court will rise.
C'est le président du Parlement.
Parle de viol, de violence, de crimes contre nature devant des gosses.
We just continue with yeah.
The court resumes with another bench. We are going to proceed with other cases. It's application number 008 of 2018 for CN, DR, and 9 others against Mali, Republic of Mali. Justice Menge will read the decision of the court. Justice Menge.
Merci, Madame la Présidente.
President, the matter of Hussein Diarra and 9 others versus Republic of Mali. And this is application number 008/2018, ruling dated 22 September 2022. The court composed of Imani D. Aboud, President, Bless Chikaya, Vice President, Ben Kyoko, Rafa Benashu, Cesar Menge, Shafika Ben Saula, Stella I. Anukam, Dumisa B. Intebeza, Dennis D. Ajay, judges and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, and 9 sub 2 of the Rules of Procedure of the Court, Judge Modibo Sako, a national of Mali, did not hear the application. Facts of the matter. The applicants allege that Analas Mali SARR specializes in testing for gold content through the use of chemicals. According to the applicant, blood tests should be carried out periodically to monitor the blood lead level of employees. They further aver that these blood tests were not carried out regularly, as some employees had gone more than 2 years without being tested due to negligence on the part of the company's management. They also affirm that for this reason, some former workers started to feel unwell due to lack of effective protection. They further aver that they were retrenched on 29 January 2009 for economic reasons, without any support and without medical assistance, in violation of all the legal and regulatory provisions under the mines collective agreement. Later, the applicants used Analab Mali SARL before Kayes Labor Court on 13th February 2012, and by decision 017 JGT 12 of 29th March 2012, the court ordered Analab SARL to carry out the lead tests or be liable to a penalty of 200,000 CFA francs per day for delay. This decision was confirmed by judgment number 07 of 4th April 2013, rendered by the Social Division of the Kayes Appeal Court. The applicants filed a new case before the Kayes Appeals Court seeking to obtain payment of the provisional fine imposed by the aforementioned judgment of 2012. In a penalty enforcement hearing, the president of the said court, by order number 09 dated 31st July 2013, granted the request and ordered Analab Mali SARL to pay 86,200,000. Following appeal by Analab Mali SARL, the Social Division of Kayes Appeals Court, by its judgment number 15 of 26 August 2013, set aside a said order on the ground that there was no need for the penalty to be paid, and declared that it lacked jurisdiction to rule on the requests relating to the defreezing asset submitted by the company, and referred it to the civil judge of Kayes. Prayers of the parties. The applicants pray the court to declare that it has jurisdiction, declare the application admissible and well-founded, enforce court decision, and restore the rights of the former workers in question. Order the respondent state to execute decision number 12 of 29th March 2012 in accordance with res judicata, or be fined 4 million CFA francs per day of delay to be paid to each worker. Order 200 million CFA francs to be paid as damages to the 10 former workers for the harm caused. Pay a cash amount of 78,671,840 CFA francs to the applicants under the authority of res judicata. Order an exit medical examination of the former workers in a neutral clinic at the expense of the respondent state, the issuance of a medical certificate, as well as the lead tests. And finally, order provisional enforcement of the decision to be taken on half of the rights. In their reply, the applicant praised the court to order the respondent state to take the following measures: bear the cost to the tune of 3 million CFA francs, pay the cost of lawyers round trip transportation and accommodation to the tune of 4 million CFA francs. For its parts, the respondent state praised the court to declare the application inadmissible in the form and at most unfounded on the merits, and dismiss the applicants in all their prayers. Find that the respondent state did not violate, they are saying that the respondent state did not violate Article 7, sub 1 of the Charter. Find that the respondent state did not violate Article 26 of the Charter. Find that the respondent state did not violate Article 2, sub 3 of the International Covenant of Civil and Political Rights. Find that the respondent state did not violate Article 14 of the International Covenant on Civil and Political Rights. Declare that the respondent state did not commit any prejudicial act in relation to the applicants and dismiss all their prayers. Declare that the judgment number 15 of 26 August 2013 of the highest appeal overturned the said order has put an end to the applicant's hope insofar as it has become final in the absence of the applicants filing a cassation appeal against the said judgment. Find that the applicants have not produced proof judicial acts they suffered and the causal link of the prejudice. Dismiss the applicants and others' requests as unfounded, and finally afford the respondent state the full benefits of submissions. Now, the operative part. The court unanimously on jurisdiction declares that it has jurisdiction on admissibility, upholds the objection based on admissibility for non-exhaustion of local remedies, declares the application inadmissible. On costs, orders that each party shall bear its own costs. Signed by the judges mentioned above. Done at Arusha this 22nd day of September in the year 2022 in English and French languages, and the French text being authoritative. I thank you.
This is the ruling. Application number 002 of 2019, Yakub Toure against Republic of Mali. This decision of the court will be read by Justice Benashe.
Merci, Madame la Présidente. Affaire Yacouba Traoré.
The matter of Yacouba Traoré versus the Republic of Mali, application number 002, 2019. This is a ruling. The court composed of Imani Diaboud, President, Blaise Chikaya, Vice President, Ben Kioko, Rafa Benarchour, Suzanne Menge, Tujilan Chizumila, Shafika Ben Saoula, Stella Ankam, Demisa Bitsebeza, Dennis D. Ajay, judges, and Robert Eno, registrar. In accordance with Article 22 of the Protocol to the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9, Paragraph 2 of the Rules of Court, hereinafter referred to as the Rules, Judge Motiba Sako, a national of Mali, did not hear the application. Subject of the application, firstly, the facts of the matter. The applicant avers that on 7 March 2006, Analabs and a group of workers, of which he was a member, concluded a memorandum of understanding approved by the Sikasso labor inspector. Under the terms of the memorandum, the employer, on the one hand, owed each of the 9 retrenched workers whose contracts had been terminated an amount of 500,000 CFA francs in settlement of their meal and overtime allowances. On the other hand, the employer reserved the right to investigate the reality and extent of the supposedly unpaid overtime of the workers retained in the company. The applicant further affirms that owing to the non-performance of the said memorandum on 19 January 2012, he referred the matter to the Bamako Labour Court, which, by judgment number 123 JGT of 21 May 2012, declared that it lacked jurisdiction and referred him to the Sikasso Labour Court for further proceedings. He submits that by judgment number 010 JMT 2013, rendered on 4 November 2013, the Sikasso Labour Court declared the action statute barred. He states that he appealed this judgment before the Bamako Court of Appeal, which, by judgment of 2 April 2015, upheld the judgment. He states that he further appealed the judgment of the Bamako Appeal Court, but I quote, "the docket has not been found after several searches with the President of the Social Chamber," end of quote, of the Supreme Court. Prayers of the parties. The applicant prays the court to find that the respondent state violated his right to have his cause heard, in particular, his right to be tried by a competent court, and secondly, his right to be tried within a reasonable time. As regards reparations, the applicant prays the court to order the respondent state to, first of all, provide him medical care in accordance with the terms of the memorandum signed by Analabs under the aegis of the Regional Inspection of Sikasso. 2, to pay the arrears of Social Security contributions to l'Institut National de Prévoyance Sociale, the INPS. 3, to pay him an amount of 10 million CFA francs as arrears of overtime payments and meal allowances. 4, to pay him an amount of 30 million CFA francs as a productivity bonus in accordance with the enforceable copy of the judgment of 15 February 2015. 5, pay him the sum of 40 million francs, CFA francs, as damages. For his part, the respondent state prays the court to, firstly, determine what is right, and secondly, to dismiss the applicant's requests. Following the consideration of its jurisdiction and establishing its jurisdiction, following the consideration of admissibility of the application, the court has come to the conclusion as per the operative part. The court unanimously on jurisdiction dismisses the objection to its material jurisdiction and declares that it has jurisdiction. On admissibility, upholds the objection based on non-exhaustion of local remedies and declares the application inadmissible. On costs, the court orders that each party shall bear its own costs. Signed by the judges and the registrar mentioned above, done at Arusha this 22nd day of September in the year 2022 in the English and French languages, the French text being authoritative. Thank you, Madam President.
This is the ruling of the court. Application 004 of 2019, Ibrahima, Podogu, and others against Republic of Mali. The decision of the court will be read by Justice Menge.
Merci, Madame la Présidente. Affaire Ibrahima, Podogu et autres.
Of Ibrahima, Podogu and others versus Republic of Mali. Application number 004/2019, ruling of 22 September 2022. The court, composed of Imani D. Aboud, President, Blaise Chikaya, Vice President, Ben Kyoko, Rafa Benasho, Suzanne Menge, Tujilani R. Chuzimila, Shafika Bensaula, Stella I. Anukam, Dumisa B. Inchebeza, Dennis D. Ajay, judges, and Robert Eno, registrar, in accordance with Article 22 of the Protocol of the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, and Rule 9.2 of the Rules of Procedure of the Court. Judge Motiba Sako, a national of Mali, did not hear the application. Facts of the matter. The applicants aver that they were employed by Universal Prestation Services, UPS, which is in charge of subcontracting staff and human resources, and were placed at the disposal of BCM Mali, the company in charge of operations in the Société des Mines d'Or de Lulu. The applicants state that on 3rd February 2009, the director of BCM Mali SA addressed correspondence to EPS by which it served notice of retrenchment of staff supply and management contract between them for economic reasons. The applicants aver that on 6 March 2009, UPS notified the KS Regional Director of Labor of a request of staff retrenchment addressed to BCM. A total of 301 workers, including 20 staff representatives, were concerned by the said request. They aver that on 19 February 2009, the Regional Director of Labor, by letter of 0055/DRTEFP and number 0056/DRTEFP, dated the same date, 19 February 2009, authorized the retrenchment of the workers concerned and also recommended the payment of their entitlements, in particular salaries and benefits due to them until the date of effective retrenchment, comparative holiday allowance, redundancy allowance, issuance of work certificates, and transportation of families for all staff recruited outside the usual place of employment at the time they were hired. They further aver that each worker was given notice of retrenchment. The applicants also aver that a list of workers who were to face retrenchment was drawn up for the purpose. A specified amount was allotted to each worker, with the whole amount 1,698,425,870 francs for 275 workers. They further consider that this amount paid by BCM Mali to cover workers' entitlement was misappropriated by UPS, which paid only part of the said entitlements. According to the applicants, Out of the 301 workers initially concerned, only 25 were paid some of their entitlements. Finally, they averred that UPS allegedly laid off workers for economic reasons and then rehire the same workers while getting rid of union leaders and other workers he had targeted. In order to obtain relief, the applicants initiated several legal proceedings before domestic courts, believing that the domestic court did not uphold their claims in the said proceedings. They brought the case before this court. And these are the prayers of the parties. The applicants pray the court to make the following orders. Order the payment of 1,698,400,870 francs. Let me take it again. 1,698,870 francs to 275 workers in accordance with the agreement signed between UPS and the workers' representative. Order the payment of 10 million CFA francs to each employee as damages. Order the payment of 3 million CFA francs as damages. Order the issuance of worker certificate for each ex-worker. Order the payment of all arrears of contributions to the National Social Security in respect of 301 workers. Order the Republic of Mali to pay the applicants an amount of 1 billion CFA francs as arrears of the housing allowances in accordance with the agreement signed on 8th December between the National Federation of Miners Energy and the mining operators under the auspices of the Ministry of Mines. Order a penalty of 2 million CFA francs per day of delay as per the pronouncement of the decision. And finally, order the provisional execution of the decision to be taken on half of the entitlement. The respondent states pray the court to take the following measure. Primarily, declare the application inadmissible, and finally, in the alternative, declare the application unfounded and dismiss it. After deliberations, the court unanimously on jurisdiction declares that it has jurisdiction. On admission, upholds the objection based on non-exhaustion of local remedies, declares the application inadmissible. On costs, orders that each party shall bear its own costs. Sign the judges and registrar whose names appear above. Done at Arusha this 22nd day September in the year 2022 in English and French, the French text being authoritative. I thank you.
This is the ruling of the court. We are raising. We are raising. The bench has been reconstituted. We In application 013-2019, Orek Dibgolongo against Burkina Faso, the decision of the courts will be read by Justice Sako.
Affaire Ulrich
The matter of Ulrich Sergio Dibgolongo versus Burkina Faso, application number 013-2019, ruling of 22 September 2022. The court, composed of Imani Diaboud, the President, Place Chikaya, Vice President, Ben Kioko, Rafa Benashul, Susan Menge, Tijulani R. Chizumina, Shafika Bensaula, Stella I. Anukam, Demisa B. Sebeza, Motiba Sako, Dennis D. Ajay, judges, and Robert Eno, registrar. Subject of the application, facts of the matter. It emerges from the records that the applicant was arrested in connection with an armed robbery incident that occurred on the night of 7 to 8 December 2014, which resulted in the death of one of the suspects in the armed robbery. Following preliminary investigations, the applicant was arraigned before the correctional chamber of the Tribunal de Grande Instance of Ouagadougou by the prosecutor of Faso. At the hearing, he admitted having participated in the commission of the offense of theft. By judgment number 1201 of 2 March 2015, he was found guilty of the offenses of banditry, illegal possession of firearms, and theft, and sentenced to 15 years of imprisonment, including 10 years without parole. The applicant avers that on 5 March 2015, he appealed to the Correctional Chamber of the Ouagadougou Court of Appeal, which, by judgment number 49 of 22 April 2016, upheld the judgment handed down by the Correctional Chamber of the Ouagadougou High Court. Prayers of the parties. The applicant prays the court to order the President of the Republic to grant him a presidential pardon, to order the due and proper commutation of the 15-year prison sentence to a shorter prison term. 3, order parole. 4, order an out-of-court settlement. 5, order financial compensation for the damage suffered as a result of the unfair court decisions against him. The respondent state prays the court to declare that it has partial jurisdiction to order the measures requested by the applicant, 2, declare the application inadmissible for failure to exhaust local remedies, 3, dismiss the application as unfounded. The operative part. For these reasons, the court, unanimously on jurisdiction, dismisses the objection to its jurisdiction, declares that it has jurisdiction, on admissibility, upholds the objection based on non-exhaustion of local remedies, declares the application inadmissible. On costs, orders that each party shall bear its own costs. Signed, Imani Diaboud, President, Blaise Chikaya, Vice President, Ben Kioko, Judge, Rafa Benashul, Judge, Susan Menge, Judge, Tijulani R. Chizumila, Judge, Shafika Bensaula, Judge, Stella I. Anukam, Judge, Demisa B. Sebeza, Judge, Modibo Sako, Judge, Dennis D. Ajay, Judge, and Robert Eno, Registrar. Done at Arusha this 22nd day of September in the year 2022 in English and French, the French text being authoritative. Thank you.
This is the ruling of the court. Application 014 of 2019, Jeremy Bagwan against Burkina Faso. The decision of the court will be read by Justice Benasho.
Merci, Madame la Présidente.
The matter of Jeremy Bagwan versus Burkina Faso, application number 014/2019. of 22nd September 2022. The court composed of Imanu D. Aboud, President Bless Chikaya, Vice President Ben Kyoko, Rafa Ben Ashu, Susan Menge, Tujilani R. Chizumila, Chafika Ben Saula, Stella I. Anukam, Dumisa B. Njebeza, Modibo Sako, Dennis D. Ajay, and Robertano Registrar. Subject of the application. First of all, facts of the matter. It emerges from the application that on 31st July 2006, the judicial authorities of the respondent state issued an arrest warrant for the applicant in connection with investigations into the murder of Mr. Nikiema Michel. The applicant has since been incarcerated in prison in Ouagadougou. On 17 January 2012, by judgment number 62 of the criminal chamber of the Ouagadougou Appeal Court, the applicant was sentenced in default to life imprisonment for murder. According to the counsel for the applicant, while the latter was in detention at the Ouagadougou prison, he was not conveyed from his cell to take part in the hearing at which he was convicted. On 4th May 2018, he filed a cassation appeal. To date, the said appeal is pending before the cassation court. Prayers of the party. The applicant prays the court to order the following measures. Order the President of the Republic to grant him a presidential pardon. Order the due and proper commutation of the life sentence into a shorter term of imprisonment. Order parole. Order an out-of-court settlement. And finally, order financial compensation for the damage suffered as a result of the unfair court decisions against him. The respondent state did not respond to the applications. Operative part. Unanimously on jurisdiction, the court declares that it has jurisdiction. On admissibility, the court declares the application inadmissible for non-exhaustion of local remedies. On costs, orders that each party shall bear its own costs. Signed, the judges and registrar mentioned above, done at Arusha, this 22nd day of September in the year 2022 in English and French, the French text being authoritative. I thank you, Madam President.
This is the decision of the court. Application number 004 of 2020, Unge Eric against Republic of Benin. The decision of the court will be read by just Honorable Vice President.
Merci, Madame la Présidente.
The matter of Ongu Eric Nudehunu versus the Republic of Benin, application number 004 of 2020.
La Cour composée.
The court composed of Imani Diaboud, President, Blaise Chikaya, Vice President, Ben Kyoko, Rafa Ben Ashu, Susan Menge, Fujilani R. Chizumila, Ben Saula, Stella Yanukam, Dumisa Tebesa, Modibo Sako,
Ajayi,
Dennis Dominic Ajayi, judges, and Robert Eno, registrar. Subject of the application, facts of the matter. The applicant affirms in the application that on 20 February 2018, he was arrested by unidentified individuals without a warrant and taken by force to a police station where he was informed of the reason for arrest, namely embezzlement of public funds through producing inflated invoices to Conseil National des Charges du Benin, hereinafter referred to as the CNSCB, an entity of the respondent state, and by subsequently cashing 2 checks drawn by CNCB in the name of the company Fisc Consult Sal. He submits that on 26 February 2018, he was presented before the public prosecutor, who charged him with abetment of misappropriation of public funds and placed him under a detention order on 27 February 2018 in the Cotonou prison. Pursuant to the law establishing the CRIET, the case was subsequently referred to the investigating committee of the CRIET in view of the preferred charge. It emerges from the records that the applicant escaped from the detention on 31 October 2018. The applicant contends that the alleged facts of which he is accused are totally fictional, and that during the preliminary investigation, he explained that he had not submitted any invoice in his personal name to the CNCB, and that all the invoices submitted by Fisc Consult Sal to the CNCB mention all the services provided and the methods of determining fees. He further avers that during the investigation, he provided evidence that Fisc Consult Sal faithfully fulfilled its obligations to the CNCB and was partially and regularly paid by the latter. He avers that despite these facts, the CRIET Investigating Committee, by judgment number 001 CRIET/COM 1 of 2019, of 20 March 2019, committed him to the CRIET Correctional Chamber for trial. He states that on 15 June 2019, he filed a cassation appeal against the CRIET's decision. The applicant submits that the Correctional Chamber of the CRIET rendered a judgment on 25 July 2019, which found him guilty of the offenses of misappropriation of public funds, complicity in abuse of office, as well as usurpation of title, and sentenced him to 10 years imprisonment and ordered him to pay an amount of 1,277,995,474 CFA francs to the CNCB as compensation for the damage caused. He further avers that on 26 July 2019, he filed a cassation appeal against the said judgment, and as of the date of filing the application, the Supreme Court has not ruled on the said appeal.
Nous passons maintenant aux demandes des parties.
We will now look at the prayers of the parties. The applicant prays the court to find that it has jurisdiction, to declare the application admissible, to find that the violations of his human rights protected by Articles 2, 11, 14, 15, 16, and 17, and 26 of the ICCPR, Articles 1, 2, 3, 7, 12, 14, and 26 of the Charter, Articles
Les articles 1, 3,
Articles 1, 3, 6, 7, 8, 10, 11, 14, 17, 19, 20, and 23 of the Universal Declaration of Human Rights, and Articles 2, 6, and 7 of the ICESCR are well-founded, and that the respondent state is responsible for these violations. Declare that the fact that the CRIET convicted him by judgment of 20 March 2019, based on false charges, and constitutes a serious his honor, dignity, reputation, health, and his right to protection against arbitrariness. Declare that he is subject to arbitrary judicial practices and persecution within the meaning of Articles 12 of the Charter and 14 of the UDHR for having ensured the exercise of the rights of defense in tax matters in Benin in his capacity as manager of Fisconsult SAL, and for having ensured the exercise of the rights of defense in tax matters for the benefit of Sébastien Germain Adjavon and the companies in which he has interests. Declare that the arrest warrants issued against him constitute a violation of the right to freedom of movement guaranteed by Article 12 of the ICCPR, of the right to stay the execution of the sentence guaranteed by Article 15.5 of the ICCPR. Order the respondent state to take all appropriate measures to annul the judgment of 25 July 2019 and the judgment of referral to the Correctional Chamber of 20 March 2019 rendered by the Create against him, and erase all the effects of the two judgments and their subsequent acts within 1 month of the delivery of the judgment. Order the respondent state to take all steps to restore his reputation damaged as a result of the decisions rendered against him. Order the respondent state to amend Articles 189 and 190 of the Criminal Procedure Code so as to be in compliance with Article 7.1c of the Charter with regard to the rights of the defense and equality of arms within 3 months. To amend Articles 481 and 594 of the Criminal Procedure Code so as to be in compliance with Articles 14.5 and 9.1 of the ICCPR without delay by removing the requirement of detention prior to the exercise of the right of appeal. Order the respondent state to take all measures to avoid any form of reprisal against him, his family, and his counsel in relation to this case and or the persons involved. To the respondent state to pay a monthly sum of 300 million CFA francs for failure to comply with the measures of satisfaction, restitution, and guarantee of non-repetition pronounced by the court. Order the respondent state to pay him the following sums. These are indicated also in point 12. To order respondent state to pay for material damage, moral damage,
700 millions pour chacun de ses 3 enfants.
For all of his 3 children, that the respondent state pay the cost of this application. The respondent state to pay them
la prise des mesures nécessaires tendant à annuler l'arrêt de la crise du 25 juillet 2019 et l'arrêt numéro 001 créé comme 1/2019.
The respondent state prays the court to declare that it lacks jurisdiction to order the necessary measures to annul the Create's judgment of 25 July 2019 and judgment number 001 Create cum 2019 of March 2019, declare the application inadmissible for failure to exhaust local remedies, find that the state of Benin did not violate the applicant's human rights, dismiss all the applicant's claims, and order him to pay the costs.
Je vais à présent donner lecture de la décision de la Cour.
Let me now read the operative part, which comprises the decision of the court. For these reasons, the court unanimously on jurisdiction dismisses the objection to its jurisdiction, declares that it has jurisdiction. On admissibility, upholds the objection based on non-exhaustion of local remedies, declares the application inadmissible. On costs, orders that each party shall bear its own costs, signed by the judges and the registrar mentioned above, done at Arusha this 22nd day of September in the year 2022 in the English and French languages, the French text being authoritative. Thank you, Madam President.
This is the ruling of the court. Application number 013 of 2020, Cote against Republic of Benin. The decision of the court will be read by Justice Bensaoula.
Merci, Madame la Présidente. Affaire.
The matter of Komekuche versus Republic of Benin, application number 013-2020, ruling of 22nd September 2022. The court composed of Imani Diabou, President, Blaise Chikaya, Vice President, Ben Kyoko, Rafa Benasho, Suzanne Menge, Tujilane R. Chuzimila, Chafika Bensaoula, Stella I. Anukam, Tumisa B. Njebeza, Modibo Sako, and Dennis D. Ajay, judges, and Robert Eno, registrar. Facts of the matter. It emerges from the application that at the cabinet meeting of 28th June and 2nd August 2019, two audit reports, one on the management of cotton sector and the other on the management of National Microfinance Fund, were made public. The applicant averts that his name was cited extensively in said report. On that occasion, the Attorney General was instructed to initiate proceedings against him. The applicant averts that he was surprised to learn of these facts in the media, whereas he was never approached by any auditing committee, which, according to the applicable principles in the matter, must comply with the principle of adversarial proceedings. He says that he accordingly brought the matter before the Constitutional Court on 11 August 2017 to find a violation of the Constitution, in particular regard to his rights. He contends that by decision DCC 18-258 rendered on 6 December 2018, the Constitutional Court of the responding state dismissed his request for declaration of the cabinet statement on 2nd August 2017 in its section entitled Organizational, Accounting and Financial Audit Mission of the National Microfinance Fund, MFN, for the financial year 2013 to 2016. According to the applicant, the decision of the Constitutional Court underpins all the grievances and prejudices that he suffered, to the extent that all the acts taken against him, in particular the issuance of international arrest warrants, the extradition request, the withdrawal of his passport, the refusal to issue tax receipts, as well as the criminal proceedings initiated against him, were based on the audit prayers of the party. The applicant, in the application, the applicant praised the court to find that the respondent state violated Articles 7 and 26 of the Charter, find that the Constitutional Court of Respondent States is neither independent nor impartial, find that the respondent state violated Articles 6 and 7 of the Charter, Articles 8, 10 of the UNDHR. As regard reparation, the applicant requests the court's order the annulment of decision DCC 18-256 of 6 December 2018, as well as the entire procedure initiated against him based on the audit report, more precisely, the one before the create, the sum of 2,286,211,898 CFA francs to be paid to him as damages. For each part, the respondent state praised the court to find and declare that it lacks jurisdiction, find and declare that the application is not admissible, find that the requests are unfounded and dismiss the acts. For these reasons, the court unanimously concluded that it has material, personal, and territorial jurisdiction on admissibility. The court upholds the objections based on non-exhaustion of local remedy, declares the application inadmissible on costs. On jurisdiction, dismisses the objection to its jurisdiction, declares it has jurisdiction on costs, orders that each party shall bear its own costs. Sign the judges listed above, as well as the registrar done at Arusha this 22nd day of September in the year 2022 in English and French languages, the French text being authoritative. I thank you.
This is the ruling of the court. Application 032 of 2020, Unge Eric against Republic of Benin. The decision of the court will be delivered or will be read by Honorable Vice President.
Merci, Madame la Présidente. L'affaire Unge Eric.
The matter of Unge Eric Mudeuno versus the Republic of Benin. Application number 032 of 2020. The court composed of Imani Aboud, President, Les Chikaya, Vice President, Ben Kioko, Rafa Benashur, Suzanne Menge, Tujilani Chizumila, Shafika Ben Saula, Stella Anukam, Dumisan Sebeza, Modibo Sako, Denis Dominic Ajayi, judges, and Robert Eno, the registrar. The facts of the matter: it emerges from the application that the applicant alleges that in a civil procedure between collectivity Unge Ganji, represented by Unge Clément and Unge Gabriel Okamanyo, plaintiff, and Akobando Benar, Amaseiler, Kuto Gabriel, Mrs. Anne Pogle, Nikuto, and Wenu Elute, defendants, before the Cotonou Court of First Instance, he had filed a voluntary intervention. The collectivity Ongo Ganji sought confirmation of their ownership of 16 hectares, 41 acres, and 84 centiers, situated in the Alga district of Cotonou, while the applicant intervened in the relation to the confirmation of ownership of a 2.5 hectare parcel of that land. He maintains that in the said case, the Cotonou CFI on 5 June 2018 rendered a judgment without his knowledge, the operative part of which reads, which is contested by the applicant. He affirms that this decision was arbitrarily deprived of his property rights over his 2.5 hectare estate located in Cotonou. The prayers of the parties. The applicant prays the court to declare that it has jurisdiction to find and draw all the consequences of the fact that the applicant is unable to produce the certificate of non-appeal in the docket before the appeal court insofar as, in violation of Article 30 of the Protocol and Article 23C of the International Covenant on Civil and Political Rights, the respondent prevented him from doing so by not executing the decisions of 6 May 2020, application number 004-2020, 25 September 2020, and that of 4 December 2020, application number 003-2020, Unge Eric Nudeunu versus the Republic of Benin. Exempt the applicant from the exhaustion of local remedies on the ground that the exercise of all local remedies was impeded by a violation of decisions of this court, on the grounds of lack of reasonable prospect of success due to the existence of impediments to the rights of defense and the right to be present at the trial, on the grounds that the procedures were unduly prolonged, and on the grounds of the unsatisfactory and ineffective nature of the local remedies in the instant case. Declare the application admissible. Find that Article 14 of the Charter applies to the instant case and that his property rights in respect of his 2.5 hectare estate situated at the Alga in the commune of Cotonou are protected by the Article 14 of the Charter. Find that the respondent state has effectively violated his human rights protected by Articles 371 and 14 of the Charter, 23, 14.1 and 26 of the ICCPR and 8 of the UDHR. Find that the respondent state has violated Article 7.1a of the Charter in that 14 years without a final verdict is already a violation of the right to be tried within a reasonable time, within the meaning of Rule 52E of the Rules of Court and Articles 7.1d and 56.5 of the Charter. Declare and rule that by preventing the applicant from producing the certificate of no appeal to this court, the respondent violated his right to an effective remedy and the right to obtain provisional measures in view of the ruling of 19 March 2021, which dismissed the measure requested by the applicant for lack of said certificate. Note and draw the legal consequences of the fact that the respondent state has not provided before this court any evidence that he was informed of the date of closure of pleadings, the date of delivery of judgment number 006 2DPF 18 of 5 June 2018 of the Court of Cotonou, or any evidence that this contentious judgment was notified to him, or any proof that he is not thus arbitrarily deprived from the right of appeal, the time limit for which has expired since 5 July 2018, or any proof that the respondent state annuls this contentious judgment as required by Article 547 of the Code of Procedure, or proof that this judgment against him is not final, or any proof of execution of the previous decisions of this court rendered in his favor. Order all reparation measures it deems appropriate, in particular to order the respondent state to seize without delay any disruption of the peaceful enjoyment of his property right, to annul decision number 006 2DPF 18 of 5 June 2018 of the Cotonou Court of First Instance as soon as this court renders its judgment. To pay him the financial damages for loss of income on his property right, of which he was arbitrarily deprived by the decision of the Cotonou Court of First Instance, to the tune of 1,250 CFA francs per square meter and per year, multiplied by the area of 2.5 hectares over the period from 5 June 2018 until the date of effective enforcement of the decision of this court. pay him the following amounts: 7 million CFA francs as cost of legal representation before the court of first instance, 14 million CFA francs as cost of legal representation before this court, and 1,500,000 CFA francs for postage and travel expenses before this court, payable on presentation of an invoice. To pay him an amount of money as the court shall determine as reparation for moral damage. Pay him compound interest at the legal rate per year on the financial compensation awarded until it is paid in full. Pay him an amount of 300 million CFA francs for each month of non-execution of the non-financial measures. Pay the costs of the proceedings. In response, the respondent state praised the court primarily to note that the applicant has not appealed the contested judgment, find that the applicant has not pursued the legal remedies in respect of the civil procedure, hold that the applicant has not exhausted local remedies, consequently declare the application inadmissible, hold that the courts are not required to give notice of an adversarial judgment, hold that the submission of alleging failure to notify the judgment is irrelevant, note that the applicant was represented by Mr. Laurent Bognon during the proceedings, find that the proceedings were thus adversarial in relation to the applicant. Accordingly, find that the submission of unavailability of remedies is specious, rule out the possibility of a cassation appeal, note that the Constitutional Court of Benin has the power to recognize the right to compensation for damage resulting from human rights violations, find that based on such a decision, a person may be awarded damages before a court of ordinary law. Find that the applicant's interpretation of the provisions of Article 410 of the Penal Code is erroneous and subjective. Declare that this article in no way prohibits the exercise of remedies. Accordingly, rejects the plea alleging the threat of deprivation of liberty, find that all the grounds for exemption from exhaustion of remedies are specious. Hold that the applicant is subject to compliance with the requirement of exhaustion of local remedies. Finally, declare the application inadmissible for failure to exhaust local remedies, find that the case was brought before the court more than 2 years after the judgment in question was handed down, hold that procedure in respect of the matter before the court has been unduly prolonged, consequently declare the application inadmissible. I will now look at the operative part of this ruling.
La Cour à l'unanimité sur la
These reasons, the court unanimously on jurisdiction declares that it has jurisdiction, on admissibility upholds the objection based on non-exhaustion of local remedies, declares the application inadmissible. On costs, orders that each party shall bear its own costs. Signed, the judges and the registrar mentioned above, Donata, this 22nd day of September in the year 2022 in the English and French languages, the French version being authentic. Thank you.
That is the decision of the court. Application 015-2021. Koume Patrice and Babasila against Republic of Cote d'Ivoire. This decision will be read by Justice Sako.
Kwame, Patrice et Babasila.
Patrice and Babasila versus Republic of Cote d'Ivoire, application number 015/2021, judgment 22nd September 2022. The court composed of Imani Diabu, President Bless Chikaya, Vice President Ben Kyoko, Rafa Benasho, Susan Menge, Tujilani R. Chizimila, Shafika Bensaola, Stella Ayanukam, Dumisa B. Nchebeza, Motiba Sako, Dennis D. Ajay, Judge, and Robert Eno, Registrar. Facts of the matter. From the application before the court, it emerges that the following declaration of the provisional results of the 6th March 2021 parliamentary elections, the applicants who were candidates in the said election brought an action before the Constitutional Council to invalidate the provisional result in electoral district number 053 Yamoussoukro, Commune 2. The applicants contend that the election in the said electoral district was marred by material irregularities and violation of electoral laws during voting and collation of the results and during the compilation of collation sheets. On 22nd March 2021, the Constitutional Council dismissed the applicant's appeal, ground that they did not produce evidence in support of the irregularities they alleged. Believing that their rights guaranteed by domestic laws and international instruments were violated, the applicant brought proceedings before this court. Case of the parties. The applicants prayed the court: 1. Find the violation by a respondent state of their rights guaranteed by domestic laws and human rights instruments. 2. Amend the results of the electoral district number 053 Yamoussoukro, Commune 2 and invalidate 76 collation sheets in 15 polling stations. 3. Declare the applicants who stood on a ticket of PDC RDA winners of the 6 March 2021 parliamentary, or order the respondent state to rerun the parliamentary elections in electoral district number 053 Yamoussoukro, Commune 2. 5. Order the respondent state to pay the applicants the sum of 150 million CFA francs as reparation for campaign and legal costs. The respondent state praised the court to 1. Rule the application inadmissible. 2. Dismiss the applicant's requests as unfounded. The operative part. For these reasons, the court unanimously on jurisdiction dismisses the objection based on lack of personal jurisdiction, declares that it has jurisdiction. The respondent state's lack of standing, dismiss the objection based on respondent's alleged lack of standing, find that the respondent has standing. Admissibility, dismisses the objection to the admissibility of the application based on the use of insulting language and non-exhaustion of local remedies. Declare the application inadmissible on merits. Find that the respondent state did not violate the applicant's right to a reasoned decision guaranteed by Article 7(1) of the Charter. Find that the respondent state did not violate the applicant's right to credible elections guaranteed by Article 13 of the Charter and Article 6 of the ECOWAS Protocol on Democracy. Find that the respondent state did not violate the applicant's rights to an independent tribunal guaranteed by Article 26 of the Charter. Find that the respondent state violated the applicant's right to transparent elections guaranteed under Article 6 of the ECOWAS Protocol on Governance by failing to comply with the regulatory requirement facts regarding the authentication of some of the coalition sheets, find that respondents have violated the applicant's right to engage political activity guaranteed by Article 13 of the Charter. Find that the respondent states violated the applicant's right to security of the person guaranteed by Article 6 of the Charter. On reparations, pecuniary reparations, award the applicant the sum of 3,485,000 CFA francs, which breaks down as follows: 1,485,000 CFA francs for reimbursement of the cost of obtaining duplicates of the voters register, 2 million CFA francs for reparation of moral prejudice that they suffer. Non-pecuniary reparation dismisses the request to annulment of the legislations of 6 March 2021 in the election district number 153, Yamoussoukro, Commune 2, on implementation of and reporting. Orders the respondent state to pay the amount indicated in under paragraph 13 above from taxes within 6 months from the date of notification of the judgment, failing which it will pay interest on arrears calculated on the basis of the applicable rate of the Banque Centrale des États de l'Afrique de l'Ouest. The respondent state to report to it on the implementation of item 13 on the operative part within 3 months from the date of notification of judgment on cost orders that each party shall bear its cost. Signed, Imani D. Aboud, President, Bless Chikaya, Benkioko, Judge, Rafa Benasho, Judge, Susan Menge, Judge, Tujilan Chuzimila, Judge, Shafika Bensala, Judge, Stella I. Anukam, Judge, Dumisa Tabitha, Judge, Modibo Sako, Judge, Dennis D. Ajay, Judge, and Robert Eno, Registrar. Danata Rusha, this 22nd day of 2020, in the year 2022, in English and French, the French test being authoritative. Thank you.
What is the judgment of the court? The bench is reconstituted. In application 017-2021, Rahim Belgev against Republic of Tunisia, and this decision of the court will be read by Justice Bensaoula.
Merci, Madame la Présidente. قضية ضد الجمهورية التونسية العريضة رقم 2021 الحكم 22 سبتمبر 2022. تشكلت المحكمة من القضاة إيماني دي عبود الرئيسة
The matter of Ibrahim Ben Mohammed Ben Ibrahim Belgis versus the Republic of Tunisia, application number 017-2021.
دينيس آجي وروبرت إنو رئيس القلم، عملا بالمادة 22 من البروتوكول المنشئ للمحكمة الإفريقية لحقوق الإنسان والشعوب، يشار إليه فيما بعد البروتوكول، والمادة 9 فقرة 2 من النظام الداخلي للمحكمة، يشار إليه فيما بعد بالنظام الداخلي. فإن القاضي رافع بن عاشور قاضي في المحكمة والذي يحمل الجنسية التونسية تنحى خلال نظر هذه العريضة.
Honorable Judge,
yes,
there's no interpretation in English.
Okay.
No, no.
in English. You're ready? Yeah.
Do I have to repeat again? I have to repeat again? No, continue. Okay. وقائع القضية يزعم المدعي في عريضته أن رئيس
017-2021. The facts of the matter, the applicant alleges in his application that the president of the respondent state abrogated the constitution, halted the democratic process, and arrogated to himself more powers by promulgating the following presidential decrees. Number 69 of 26 July 2021, pertaining to the termination of the duties of the head and members of government. Number 80 of 29 July 2021, pertaining to the suspension of the powers of Parliament, lifting the immunity of its members for 1 month, starting from 25 July 2021, subject to extension by a presidential decree as per the provision of Article 80 of the Constitution. Number 109 of 24 August 2021, pertaining to the extension of exceptional measures on the suspension of the powers of Parliament and lifting the immunity of its members until further notice. Number 117 of 22 September 2021, pertaining to exceptional measures, Article 20 of which revokes the Constitution except chapters 1 and 2, and maintaining the provisions which do not contradict with the presidential order. And numbers 137 and 138 of 11 October 2021, pertaining to the appointment of the head and members of government, respectively. The applicant asserts that the above decrees unlawfully terminated the functions and appointment of the head and members of the government and suspended the powers of Parliament and the provisions of the Constitution except the preamble and chapters 1 and 2. Prayers of the parties. The applicant prays the court to issue an order for provisional measures to put an end to the so-called exceptional measures taken by the respondent state and return to constitutional democracy and respect for the Constitution. The applicant also prays the court to declare that it has jurisdiction and to declare the application admissible. He also requests the court to declare that the respondent state has, by promulgating the aforementioned decrees, violated both his rights and the rights of the Tunisian people, particularly the right of people to self-determination guaranteed under Article 21 of the Charter, the right to participate in the conduct of the affairs of the country guaranteed in Article 13(1) of the Charter, the right to enjoy democratic values and human rights enshrined under Articles 2, 3, 4, 5, 10, 11, 14, and 15 of the ACDEG, that is the African Charter on Democracy, Elections and Governance, the right to have the guarantees of human rights protected by Article 1 of the Charter, the right of access to justice guaranteed by Article 7 of the Charter. The applicant further requests the court to order the respondent state to appeal all the 6 presidential decrees listed in paragraph 3 above, namely number 69 of 26 July 2021, number 80 of 29 July 2021, number 109 of 24 August 2021, number 117 22 September 2021, and number 137 and 138 of 11 October 2021, and to guarantee the human rights set out in the Charter and the other instruments by taking the following measures. Adopt the legislative and regulatory instruments to ensure the supremacy of the Constitution, including the speedy operationalization of the Constitutional Court and the removal of all legislative, regulatory, political, and practical challenges hindering it. Pass laws that criminalize participating in and supporting constitutional change of power. Pass laws that guarantee the inculcation of the democratic culture in the people, in particular the young people. Provide effective procedural avenues to remedy the violation of the Constitution, pending the operationalization of the Constitutional Court by ordering the respondent state to submit to the court on the procedures for the execution of the judgment and guarantees of non-repetition. On its part, the respondent state requests the court to find that the applicant has not exhausted all local remedies, no evidence of human rights violation has been provided, the subject of the case infringes the principle of national sovereignty, dismiss the application in full and on the merits. For these reasons, the court unanimously on jurisdiction dismisses the objection to its jurisdiction, declares that it has jurisdiction or admissibility, dismisses the objection based on the failure to exhaust local remedies, declares the application admissible on merits, finds that the respondent state has violated the applicant's rights to be heard under Article 7(1)(a) of the Charter, as read together with Article 26 of the Charter, finds that the respondent state has violated the applicant's rights to participate in the conduct of public affairs in his country under Article 13(1) of the Charter, and finds that the respondent state has violated Article 1 of the Charter. On reparations, court orders the respondent state to repeal Presidential Decrees number 117 of 22 September 2021 on the request for provisional measures, finds that the request for provisional measures is moot on because exhaustion of local remedies has not been carried out. Finds that the respondent state has violated the applicant's rights to be heard under Article 7 of the Charter as read Article 26 of the Charter. On reparations, orders the respondent state to repeal Presidential Decrees number 117 of 22 September 2020, which decrees number 69, 8, 109 of 26 and 29 July, 24 August of 2021, and decrees number 137 and 138 of 11 October 2021, and to return to constitutional democracy within 2 years from the date of notification of this judgment. On implementation and reporting, orders the respondent state to report to the court within 6 months from the date of notification of this judgment, and on the implementation of item 8 and 9 of this operative part, and every 6 months thereafter until the court considers that there has been full implementation thereof. On the request for provisional measures, finds that the request for provisional measures is moot. On costs, orders that each party shall bear its own costs. Signed, the judges cited above and the registrar. Done at Arusha this 22nd day of September in the year 2022 in Arabic, English and French, the Arabic text being authoritative. Thank you, Madam President.
This is the judgment of the court. And this makes the end of our delivery of judgments or decisions of the court. We thank you.
Ko